It still runs good? It's all that matters. Ah, fine.
Oh my, the wrong one. Assalamu alaikum wa rahmatullahi wa barakatuhu. So we still have some people coming in, but thank you everybody for being here. I think we have some people still praying, so we'll wait for them to finish. Sisters, if you would like to come down, there's space here for you, and that way you can hear us and see us too. Please come down. If you're finished praying, the sisters, please come downstairs. Brothers and sisters, I don't know about you, but there's one thing we can all agree on is the weather here in Texas changes very quickly. Just 2 weeks ago, right, we were supposed to have this event. We had to reschedule it because of the storm that rolled through, right? And then today, subhanAllah, 80 degrees and sunny. That's Texas for you, right? If you don't like the weather, just wait 5 minutes. But one thing I can say for sure is that if our plan for weather changes so quickly, just imagine what happens if we don't plan for the big things in life, how quickly things can change. So may Allah protect us all. I mean, yeah, but it works good for other things. Yes. I don't even know if we need the microphone, really, if everybody's downstairs. Yeah, it'll probably be better. You don't know. Perhaps there are people still upstairs. That's really good. Oh, the tilt. वो नीचे थोड़े से screws होते हैं वो थोड़ा सा adjust कर लें.
Assalamu alaikum, everybody. Welcome to the event. Jazakallah khair for showing up, inshallah. I humbly request the sisters, if they like, they can come downstairs. We have the chairs in that small room in the area, inshallah. And we're going to be about to start the event, inshallah, with the introduction by Brother Bilal, inshallah.
What do I get? But we don't need all this. Let's try to make this bigger. Nope. Got it. That's true leadership right there. The two leaders are now praying their Maghrib namaz. Okay, let's go ahead and get started. Assalamu alaikum wa rahmatullahi wa barakatuhu. Okay, brothers and sisters, everyone, thank you very much for being here tonight. My name is Bilal Siddiqui. I'm an attorney that lives and works here in Prosper. I have my own office here in Prosper in the community. It's on 1st Street in Preston, behind the CVS in the Caddo office building. My practice involves mostly contractual work, business matters, whether it's drafting or disputing contracts or anything like that, and then real estate matters, so closings, buying and selling properties. Over the last almost 13 years that I've been practicing law, I've done various different things, worn many different hats, but that's mostly what my practice entails now. Hopefully everyone can hear me okay. Is there sound is good? I don't want to yell. It's kind of a small group. Are we good? Okay. So tonight I get the privilege to be presenting here with Brother Fawaz Maroof. He's a colleague of mine. Brother Fawaz Maroof is a SMU law graduate who has his own practice here in DFW. Specifically, he's in the Allen area. His office focuses primarily on Islamic estate planning, which includes wills, trusts, and other related documents. I had the opportunity to attend a presentation that Brother Fawaz Maroofi put on. It was tailored for attorneys. It was a continuing legal education course, and I really enjoyed it. It was well attended by many of my other colleagues. It was very intriguing, very thought-provoking, you know. And I'll touch on that in just a moment, why I say thought-provoking for me personally. And it was very highly informative. So when I was asked by the ICPC board to do a presentation on this topic, the first person I thought of was Brother Maroof here. When I brought the idea to him, he was very welcoming, and he was looking forward to coming out here and meeting with the community members, and I think really he was looking forward to seeing the masjid here in Prosper. So I'm glad that you were able to make it out today, Brother Fawaz. Thank you. Brother Fawaz knows wills and trusts and traditional Islamic estate planning, as well as Texas law when it comes to estates in general. So I'm genuinely happy to be here and to share the stage with my brother. Thank you to Brother Fawaz Maroof for coming out here on behalf of the Prosper Muslim community. And of course, thank you to the ICPC board for putting together this event, which is a very important topic, where we'll be discussing a topic that's important, but unfortunately it's often overlooked by many folks. Just a couple of quick housekeeping items that I wanted to mention before we dive into the presentation. Brother Fawaz and I are both different practices. We don't have the same office. We have separate practices, separate offices. Nothing we say here tonight and the discussions that we have before or after today's presentation will create any type of attorney-client relationship. The deck that we're going to present and the materials we're going to present should be very informative, but we welcome any questions. We would just ask if you can, unless it's really important, we can try to reserve the questions till the end. We're going to leave plenty of time for that. So if everybody's okay with that, let's go ahead and get started, inshallah. Let's talk about protecting your family by planning for your incapacity or death using tools that can be helpful during your lifetime, as well as other tools that only really come into play when you pass away. I wanted to share an ayah of the Quran, Surah Al-Anbiya. A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Kullu nafsin da'iqatul maut. Every soul will taste death. That is something that we know as Muslims, that this topic is very important to us. That's why we all spent our Friday night and we took time out to come here today, right, and get together, alhamdulillah. That planning for our families after we pass away is part of our responsibility as Muslims. The Prophet ﷺ encouraged us not to leave our families in hardship. In addition to spirituality and what I just mentioned, there's a practical side. And that's where the legal tools we'll discuss tonight come into play. Now I'm going to hand it over to Brother Fawaz Maroof to walk us through the foundations of Islamic estate planning and how that fits in with Texas law.
Thank you so much, and thank you for putting this together, and thank you.
I was like, I sound way louder. Should it just be?
Test.
There we go. Thank you.
Yeah, thanks for everyone putting this together. Thanks for being welcoming. It's my first time at the Prosper Mosque.
I think it's good. I think it's good.
Okay, so I do appreciate it. I'm glad to come and visit this mosque. It's my first time here. I lived in Frisco for quite a while, so I'm familiar with the Frisco Mosque, and I live in Allen now. So once he told me that there's a mosque in Prosper, I knew I wanted to come visit and meet everyone here. So I do appreciate that. So I do want to just touch base a little bit about my background. Of course, I focus on estate planning, making sure your estate plans are compliant with Texas law. And I focus on the Islamic basis, making sure the distribution as much as we can is distributed according to the Quran and following the Hadith, so Islamic principles. My background, I did a lot of title work, a lot of property title work, so I would see when people died without a will or with a trust based on Texas law, I would make an opinion on who owns it based on Texas law, whether they died without a will, or with a trust. So having that knowledge, I understood the Quran specifically mandated specific heirs, specific beneficiaries at the time of death. So those are the rightful heirs to your assets. And I knew that and I wanted to make sure that's in a legal document where you can fulfill your religious obligation in a Texas compliant matter. So speaking about the Quran, of course, there's authentic hadith that says the Prophet ﷺ said it's not permissible for any Muslim to have something to will for 2 nights without having a last will and testament. Basically having something in writing, these are the heirs. And the Quran specifically states who the heirs are. If you have anything to will, if you own anything and you pass away, these are the beneficiaries, and this is who should get it. So living in the States, the only way to do that is by having an estate plan, whether it's a will or trust, but having a legal document that'll enforce that. So
Maybe ask the question. Perhaps, and it's a good time? Okay. Well, I thought that it might be a good time. So this is just a genuine question that I had, and I kind of alluded to it earlier in my in my introduction. So I just wanted to bring it up, and you don't have to raise your hand or anything like that. But I was really curious as to how many people have actually thought about estate planning, and how many people have actually done it. I just really wanted to do good. Okay, good. You raised your hands. I really wanted to use that as an opportunity to share personally on my side that even, as I mentioned, as being a licensed attorney for 13 years, I just recently have done my estate planning. I put it off for a very long time. Life got in the way. I have many excuses that I can share with you, but I just wanted to share that as well, that we took a long time to think about it, and we delayed it for a long time, but when we actually started to do it, it did not take that long. It was not difficult. And the relief and the peace of mind that I have after I completed that was immense. So I was in that boat that I was waiting and I was finding every excuse, and it's too much, it takes too much time, I don't need it, I don't have anything, all those excuses. Really, once we did it, for me and my family, it was game changing to know that Allah not gonna, something happens to me tomorrow, and I say that knowing that I don't know how many of you were at the third Jummah today, but we talked about how Ramadan is upcoming, and whenever I'm at home with my family, we always talk about this, that I live with my parents, so we're always talking about how this could be our last Ramadan. Today we're on the blessed day of Jummah, and it could be our last Jummah. So let's just say, God forbid something happened to me, I now know that where will my kids go? What will happen with my estate? All those things. So that peace of mind I wanted to share, and assume that a lot of people here have not done those things. So I wanted to share personally that it's okay. It's never too late, and once you do actually do it, it's a great feeling. So thank you. I wanted to share that.
Yeah, thank you. That's a good point. A lot of my clients that come up, they all say, I've been thinking about this for a while, I haven't done it. People procrastinate with it. They don't want to think about it because, it's just not something on top of their list, but they know that they have to get it done. I would say, of course, do it as soon as possible, and I'll explain the reasons why if you don't have an estate plan. And it's two reasons. Number one, you want to make it easy on your family. That's your number one goal. If I pass away, everything I worked hard for, I wanted to go to my family without them having to deal with anything. Let me do all the stuff now, so it'll be easier for them in the future. And number two, to abide, to Islamic principles. If the Quran says it, at least you did your part. You said, this is what I want to happen. It's going to be distributed Islamically, and you fulfilled your religious duty. So those are the two main points you want to take away from it. I did probate court as well. So probate court is the court process after death, and so it's a full court process. So if you pass away without a will or a trust or some kind of beneficiary designation, you have to go through a process, or your family does, called probate court. You hire an attorney, they file an application, there's a court hearing or multiple court hearings, and they oversee the whole process. So if you pass away without an estate plan in general, number one, Texas law controls. It's called Texas intestacy, meaning if you pass away without a will or estate plan, Texas determines who the heirs are. So it's automatically contradictory to the Quran, because they say, if you pass away and these people are living, these are the people that are the beneficiaries, really whether you like it or not. It's a longer court process, it's heavy attorney fees, and it's just not a pleasant process to go through at that time, when family is going through everything else at that point. So that's what happens if you don't have an estate plan usually. And if you're married, of course, that'll happen for you and for the spouse. So it's two separate processes. And so you want to have some kind of estate plan. The two main types of estate plans in Texas are whether you want to do a trust or whether you want to do a will. So whenever you want to decide what kind of estate plan do I want to do, it's really just deciding, do I want to do a will or do I want to do a trust? Getting an attorney, and as he said, once you do it, it's not as intimidating. It's mostly a simple process. It's just a matter of deciding which route you want to go. So I do want to talk about wills first. The will is a simple document where you determine who your beneficiaries are. So that's a portion where you can make sure it follows Islamic principles. In the different scenarios, so you follow the Islamic law by putting who the beneficiaries are at the time of death. You also pick an executor. An executor is the person responsible for your estate. For example, I picked my wife if she's around. That means anything I could do, she would be able to do. She can access my accounts, she can sell properties under my name, and so forth. However, a will also goes through the court probate process. So there's a few different types of probate process, but the main ones are intestate or testate. If you die without a will, it's intestate. It's a longer probate process, takes weeks to months, multiple court hearings, and attorney fees, market rate, just ballpark figure, generally starts off at 5,000 for if you don't have a will. If you have a will, generally flat fee, ballpark figure is about 2,500, and it's an easier court process. It's more streamlined, but you still have to get an attorney, you have to go through court hearing, and only at the time of court hearing is when my wife can be appointed as executor, then she can access my assets. So I did probate as well, and I still do it right now. I've seen situations where it takes weeks or months for someone to even access the bank account or have be able to rent out the home or sell the home where they needed the finances. So keep that in mind whenever you decide between a will and a trust. It's really determining whether you want to go through probate court, your family, or if you want them to avoid it. So to summarize with a will, you pick the person in charge at the time of your death, you pick the beneficiaries, funeral rights, all of that good stuff in there, but there is a court process. And now I'm going to talk about the second type of estate plan. It's called the trust plan. So basically what I'm going to focus on is revocable living trust. There's a bunch of different types of trust, but revocable is what I want to focus on today. Revocable means you can revoke it, you can terminate it, you can add properties, take out properties. Anything you can do today, you can do with the trust while you're living. It has the same concept. Instead of executor, the trustee is responsible. For example, me and my wife are currently the trustees of my trust. If I pass away, my wife is automatically in full control. If she's not around, then we appoint someone else. Those are already in the terms of the trust. You name the beneficiaries so you can comply with Islamic law. And the benefit is there's no probate court. Why is there no probate court with a trust? As long as you transfer all of your assets in the name of the trust, where it's not under your individual name at the time of death, there's nothing in your name, there's no need for court. All your assets are now subject to the terms of the trust, which are basically a substitute for the will. The person responsible for your assets, for example, in my situation, my wife, the next day she can have control and access my accounts, sell my house, anything I could do, she could do immediately because that's what the trust calls for. And that's what is in the house is currently owned by the trust, for example. And it's also a private document because it doesn't go through the probate court process which is all public. Whenever you go through court, it's all public information, the will, all of that. You get to avoid that. But you do have to transfer your assets to the name of the trust while you are living. So I want to quickly give you a snapshot of the two. So the wills, and there's no right or wrong answer. Wills are fine, trusts are fine, but just have an estate plan, because if you don't have anything at all, automatically you lose control of who the beneficiaries are. You lose control of who the executor, who's in charge of your estate, and it's a longer court process, more attorney fees, avoided at all costs by having something set up. In general, wills are simple to set up. They're more cost effective. You sign it, you're done. There is a court process after death for husband and one for wife. Now the trust is a little more, costs more to set up, and after you sign it, you have to take the step of adding properties to it, because anything owned by the trust is avoiding court. If you don't add something to the trust, even if you have it created, you forget to add your house, that's subject to probate court. You just want to make sure it's all under the umbrella of the trust. So there's an extra step of funding the trust. We'll talk about that a little bit. But you do avoid court. So simply, whenever you make that decision, do I want something simple, cost-effective, but my family has to go through court? Go with a will. I want to do a trust. I want to add the assets to it. I don't mind the extra cost. Go with a trust. I always recommend if you have the means to do it and you're ready to do the legwork up front by adding the properties in there, definitely do the trust. It's avoiding a big headache for your family in the future just by avoiding court. And just to touch a little bit about common questions, with a trust, you shouldn't look at liability protection, because with a revocable living trust, husband and wife are trustees, meaning managers. It's taxed under your social security number because it's a pass-through entity. You keep your homestead protections as far as your home. Any benefits you have today, you have them with the trust. It's not a separate entity. So it's as if it doesn't exist, but it avoids probate court. You want liability protections, all of that. That's where you add LLCs to it, where the trust is a manager or owner, and Bilal will talk more about that. That's his specialty. So that's generally what I wanted you to think about when you want to go with these. So as I said, with a will, you sign it, you're done. With a trust, let's say you sign it, now you need to add properties to it. Let's add all our properties to it. That's called funding the trust, and that's what we're going to focus on the next slide. So now the trust is created. It's an empty vessel. Anything owned by it is subject to the terms. The trustees are laid out, the beneficiaries are laid out, and you know that it's going to avoid, inshallah, probate court, anything that's owned by it. So let's talk about a few main topics or few main types of assets that you might have. Number one is beneficiary accounts. 401k, IRA, crypto accounts, life insurance. Any of these are managed by separate companies. Each company, the way they work is they ask who's the beneficiary upon death. You might have already named your spouse or your kids. They pay them directly. They don't care if you have a will or a trust. You name this person, this is who's getting it. Now, with a trust, you can keep that, but if you want everything to flow Islamically, you would name the trust as a beneficiary. The beneficiary account would still be titled under your name, but the beneficiary upon death is a trust, and it'll flow Islamically. So that's the way to handle beneficiary accounts, by naming the proper beneficiary in there, and a trust could be a beneficiary. Bank accounts is a second category. The way that's handled is you make an appointment with the bank after you create the trust, and you say, hey, I want to make the bank account subject to the terms of the trust, meaning if I pass away, here's the next trustee. If both of us pass away, my brother's name next, he has access to it, and he can distribute it to my beneficiaries. You generally have two options. You can convert the bank accounts to trust accounts. Same account number, same routing number. Now they're just subject to the terms of the trust. The bank has the trust documents, so they know who has access to it. Second option is you can name the bank as a beneficiary upon death, similar to the beneficiary accounts. Nothing changes, only at the time of death. The trust has control of it, and the trustee owns it. No need for probate court. There's someone assigned, someone has authority. This is the number one thing I've seen, and a lot of attorneys said the same thing, where when they come up to me, they say, hey, someone passed away. I'm not able to access the account because I told them they passed away. They'll freeze the account. If there's no beneficiary named, it's not a trust account, it's under husband's or wife's name, and they passed away, they freeze it. They don't want to have the liability of fraud or anything else. They say you need to go through the court process and show us the executor who has authority over it. Naming the trust there, the trust already has these people assigned, which can be amended at any time. So it's good to have the bank account either converted to a trust. Property and business assets, which he specializes.
Jazakallah khair. Brother Fawaz, I don't think it could have been a more perfect timing for the microphone today, right as you were wrapping up, but we're going to come back to you, but I'll just jump in here briefly, just for a moment to talk about some of the business and property side of things, because a lot of families, as I know, in this community, and having lived here for several years now, and speaking with several of the people here and some of the friends I have, that we have businesses, we have partnerships, we have interests in rental properties and those types of things. So I think that this will be really important discussion, and something that you'll probably be thinking about, and we can discuss after our presentation is complete. So here's the key point that, when we're talking about business and property, that I want y'all to think about, is that your legal ownership structure matters just as much as the estate planning that we're talking about. That's the main takeaway here, is that your estate planning matches what you have written on your operating agreement, on your deed, for example. So if you have a business or rental property, you might have an LLC or a partnership agreement, some sort of company agreement, or even lender restrictions on title if there's mortgage or financing involved. Those documents don't automatically know about the will or the trust that we're talking about here tonight. So part of the estate planning is making sure that your business agreements and real estate documents match your trust, so that what you intend to distribute and how you intend to distribute, distribute your estate upon your death is done correctly. So in practice, what that means, and what I see with my clients, is that we will do what Brother Fawaz has already mentioned, is listing the trust as a member or a manager of that LLC. Sometimes, if you've already created your LLC and you've been in business for 10 years already, it might be a good idea to revisit those agreements. So you might have to review and update your operating agreement to recognize that trust. Also, when I do those types of reviews, I look for things like buyout provisions, something that makes it so that you have made this plan, you have this intention, however, there's something in the contract that actually prevents you, that maybe the other partner has the first right of refusal, or they're able to buy out that part of the business that has become available because of your passing. So those types of language in the contract do matter, and those are those things that don't matter while you're alive, and then when that time comes, that all of a sudden now it is important. As we all know, most people, if everything is going great, we don't even look at the contract, but those are those situations and those real life examples that do arise. Obviously we're not giving legal advice here, but again, I want you to walk away with that main concept when it comes to your business and your properties, that you need to coordinate both your estate plan and your ownership documents so they match and they don't work against each other. There's a few examples here that we came up with that I wanted to share here, and I think we have the time, so I'm just going to go read a few of the examples. Brother Fawaz has trusted me with this, so I'm going to go ahead and mention these, but I think these are very relatable. But the first example is pretty much the one that I was just talking about, and that is a family who has an LLC and they have a rental property. So imagine you and your spouse own a real rental property, but instead of holding it in your individual names, you've created an LLC. That's a smart move during your lifetime, right? It's protecting you from your liabilities. It's separating your personal and your business assets. Great for your lifetime. But here's the disconnect that happens, and what hits people is that you might prepare your beautiful Islamic trust doing everything right. You might allocate your assets just the way that you intend to do so. But if the rental property itself, the interest in it is still in your personal name, or controlled by an operating agreement that does not include the trust, there's no mention of the trust in your operating agreement, then your trust may never actually own the rental property when you pass away. So one practical and pretty easy way to fix that is that you go ahead and you make your trust the member or manager of the LLC. You can update your operating agreement. If you don't have an operating agreement, that's a good time to come up with the operating agreement, and what you do is you list the trust as the owner. And then also, there's other things related to lenders, and I don't want to get too much into the weeds, but if there is a mortgage or a finance related to a property, maybe a commercial property, for example, those are those types of things that you really should sit down and perhaps with an attorney, and you sit down and you talk through those things and really put some thought into them. So that's one example. The other example, which I know for a fact is relevant to people in our community here in Prosper, is that you and your brothers or your family members or friends own a small business together, an LLC or a partnership. That operating agreement, assuming you have a properly structured operating agreement, it probably has likely rules about who can be the owner, how ownership transfers on death, and whether a trust or heir can actually step in. If you just rely on a will or a trust without amending that agreement, you could create disputes among the partners, barriers for your family to step into the ownership, or force buyout terms you didn't anticipate. So part of the effective planning is reading those documents again, updating them, and ensuring your trust is recognized within the language of those company agreements. So just to wrap up, I had a couple other examples here, but I'm just going to go ahead and wrap up some of the examples and again just talk about that main point. So the goal ultimately is to avoid probate court and spending too much time in probate court, right? So if you have a will, you go to probate court, much easier process that Brother Fawaz mentioned here. But to try to avoid probate when it comes to your business side of things and your real estate side of things, it's not enough to just have an estate plan or a trust on a piece of paper. You have to make sure your assets are actually owned and structured so that the plan works in reality. So proper planning ensures a clear and efficient transfer of ownership upon your death. So those are just a couple of the examples that came to mind and I thought were relevant to this area. Brother, do you have anything else that you wanted to touch on real property or business assets?
No, you did. You basically touched on all the points as I would have, and thanks for providing those examples. Those are the ones I see most common. That's generally it. The only thing I want to touch on real property is, as I said, you do get the homestead exemption if you have it now, and Texas law and federal law have laws where the mortgage usually has a due on sale clause, meaning you can't transfer it to anyone without the lender's consent, or they can call the mortgage due. That does not apply to revocable living trusts if they meet certain conditions. Both of you are trustees, beneficiaries, the revocable trusts that are generally created for the, estate planning purposes. So there's federal and state laws that say this does not apply, so you don't need to get their permission. I always say it's good practice. Go ahead, get their permission in writing, peace of mind, and transfer it. But that's generally it. You covered everything else.
Thank you. And that's specifically the one that I was alluding to, so you worded it very well, and hopefully that concept has been understood. And again, we can talk about that more length after our presentation. So I'm going to go ahead and move over to the next slide, which is covering the power of attorney and other ancillary documents that come up. So when we're talking about estate planning, right, you make that decision on if you're prefer to have the wills or if you prefer to have the trust. But in general, there's more documents as well, right? I think that most everyone here has heard of these concepts already, but maybe not put a lot of thought into them. Again, I know I was not thinking about them the way I should have, and I thought about for my clients and for everyone else except for myself. So, having talked with Brother Fawaz and really spent a lot of time over the last couple years thinking about this stuff, and I have real life examples where these came into place in my own personal life and they helped. I think that this is an important slide for that reason. So we're going to be talking about 3 different documents that are part of your estate planning typically. Now these documents can be done separately, of course, but you will be getting this done when you're doing your entire estate planning. And those 3 documents are your medical power of attorney, your durable power of attorney, and your advanced directives. So first thing I want to talk about is around the durable power of attorney. I might call it a DPOA, but a durable power of attorney, what is it? It is a legal document that authorizes a trusted person to manage your financial and legal affairs on your behalf. A DPOA, is in effect if you become mentally or physically incapacitated. It's a completed, signed, and notarized document, but it's not something that has to be filed with the court. So you stand up a durable power of attorney, you complete the form, you sign it, you have it notarized, and you keep it in your possession for that rainy day or for that need that arises. So this durable power of attorney is a very practical document. It's often overlooked, especially with younger families. The power of attorney lets someone you trust manage your financial and legal affairs if you're alive but unable to act for any reason. So some examples, easy examples, are that you're traveling, you have a surgery, you fall ill all of a sudden. This is when those durable power of attorneys come into place to manage your your non-medical related things such as your legal or financial affairs. So what I'm talking about here on this slide is not about death. It's about incapacity, which is actually a much more common thing. If you don't have a power of attorney, your spouse or family may need to go to court for simple things just like bank-related items or paying bills or just managing your day-to-day affairs. So in the same way that a will or a trust deals with the affairs after your death, a power of attorney helps protect your household while you're still alive. A very simple example, but I think this will drive the point home, and it's a very relatable example, but a simple example that I'd like to share that will help illustrate this concept is that you're traveling abroad for work and something happens to you. Your spouse reaches out to a bank or to your accountant to handle some daily affairs. The first question they ask is, who are you? We need a power of attorney. If you don't have one in place and that document's not already been signed before that incapacity came into place, there's really not anything you can do in that situation except for end up in court and try to prove that you are the spouse, that you are responsible, that you are able to take care of these things. They will basically tell you, we cannot talk to you and we cannot take those actions that you've requested. So we all need to treat a power of attorney as one of those pillars of our planning. So it's a separate document. It's something. It's not something that's optional, though. In my opinion, it is something that is more than just paperwork. It's something that we should all have, a durable power of attorney. And if you already have a durable power of attorney and you've completed that properly, one thing that you should know is that if you do create another durable power of attorney, it extinguishes the previous one. So the second document I want to talk about is the advanced medical directives, sometimes referred to as a living will. It's really just talking about what your wishes are while you're still alive. So the doctors here in the room, medical professionals, you'll know this, right? Me personally, and I'm sure folks can relate, but this is just a recent example for me that last week, for the first time since I lived in Prosper, I had to pick up the phone and call 911. Somebody in our family had a medical emergency, and I had to get them out right away. As I'm following the ambulance to the hospital, and I'm thinking, hey, what's going to happen here? I did think about those documents, and I thought about all that stuff. Of course, I didn't have it with me, no big deal. You don't have to have it with you at all times. You just have to know where it is and all that stuff. So, Allah protect us all, but, if you ever find yourself in that situation, or you have found yourself in the situation, you'll know that that doctor or that medical provider, one of the first questions they're going to ask you, does this person have a medical power of attorney? Do they have any medical directives? And when that question is asked, again, you don't have to have the document in your briefcase, in your hand, or in your car at all times. I guess you could take a picture and save it on your phone and have it in that sense. Nowadays, that would probably be a good idea. But I will say that, to produce the actual document, you don't have to have it right away. But one thing that would be very scary is that when you're asked that question, that's the very first time you even thought about it. So let's think about it now before we get to that time. Also included is another document that I'd like to share, is that there's the HIPAA, authorization and release. Within this entire estate planning, if you get it done right, it will have that release, so that down the road you have all this stuff structured, and then HIPAA, privacy, health-related privacy comes into the way. So you also have a release there that is saying that, look, I authorize and release, I give the right to this person that I trust to make decisions, and you can't really make a decision unless you have all the medical information. Again, people find themselves in a situation that, look, I have to make this decision for my loved one, but I'm not able to even view all the records because of all these privacy laws. So you'll get an authorization and release that allows you to actually review all of the medical documents and then make a decision for your loved one. The third document that I'd like to talk about here is the medical power of attorney. A little bit different than your durable power of attorney, right? The durable power of attorney that we talked about first is a lot more detailed. It covers everything basically but the medical part, right, if you choose for it to do so. But the medical power of attorney is a legal document that designates a trusted person, who is the agent or the proxy, to make healthcare decisions on your behalf if you become incapacitated or are unable to communicate. It is a critical type of advanced directive that ensures your wishes regarding medical treatments, procedures, and end-of-life care are followed when you cannot speak for yourself. Each one of these, again, can be done separately, but typically they're done all together. And for me personally, that's how I handled it, was that I handled all these things together, and that I made sure that I had medical power of attorney, who was my spouse, and I have that part spelled out, but then also the durable power of attorney that covers everything else, your real property, your various different assets, and finances. So there's a couple things, and I imagine we might have some questions about durable power of attorneys, but I do just want to mention one thing that causes confusion and some people think about, and you might have this thought in my head, is that I know I did, that I had other power of attorneys out there, and they were for a specific purpose. So I had a power of attorney You might not even realize you have it, but maybe for your financial advisor, for some other, maybe for lenders or something like that, you have a power of attorney out there. Just know that if you do a durable power of attorney, it's not extinguishing those specific power of attorneys that you've put together. Perhaps you did one for your business or for a real estate transaction. Just know that if you do a durable power of attorney, it does not extinguish those specific power of attorneys that you've done before. Please correct me if I'm wrong, but that's my thoughts on that. Thank you very much. I'm going to hand it back to Brother Fawaz for guardianship, which is a very important topic. I know it is for many folks. If you have kids or elders in the family, guardianship will apply to your children, and then also can apply to elders or wards of your family, maybe a disabled person. Please, Brother Fawaz, please take over the guardianship, and then inshallah we'll do the closing.
All right, thank you. That's a great explanation of the powers of attorney and the importance of them in case you're incapacitated. Guardianship declaration should also be part of every estate plan document. What that is, God forbid, no one wants to think about this, you have kids that are under 18 or minors, disabled, so in both husband and wife, mom and dad pass away and the kids are still minors. That situation, there's a court proceeding separate from your estate, is to determine who the guardianship is of the children. With a guardianship declaration, you're specifying, this is who I want to be the guardian. If they're not around or don't qualify, this is my next choice. Same thing, if they don't qualify or not around, this is my third choice. You can have as many choices as you want. So there's two types of guardianships in Texas. Guardian of the person and guardian of the estate. Guardian of the person is basically the one that makes the personal decisions for the child, including where they live, medical decisions. Guardian of the estate is the one that manages their finances. This is generally the same person. We pick the same person to manage all of it, but you could specify, I want this as a parent, I want this as the financial manager of my child. So at the end of the day, the judge decides who the guardian is based on the best interest of the child, but at least your wishes are there, and the judge will see if this person qualifies or doesn't qualify. They check everything. They check credit, they check where does he live, and then the judge ultimately decides, but at least you have some control, letting the judge know this is who I want, instead of the judge making it blindly and saying this is who the guardian is. So this is an important document to include. This is an important part also. Let's say you have a will or a trust, and you name one of your kids as beneficiaries and they're under 18. This generally goes to the guardian. The money would go there unless the mom or dad are living, because the kid's too young to hold money or hold property. So this is why it's important to pick a guardian you trust. But if you want to safeguard the inheritance, you don't want this guardian to have it blindly without any guardrails, there's something called a contingent trust. This can be applied with a will or with a trust. It basically says if any of my beneficiaries are under 18, if they're minors, and mom and dad are not around, then it goes into a separate trust for their benefit. It could only be used for medical needs, for necessities, and then when they're 18, it's released to them. Now they can own it. So this safeguards it. They would have to create a bank account for it, and everything's accounted for. That way they can't squander their wealth. So if you are worried about who the guardian is in the future, just say, I want to have a contingent trust, hold it in place until they're 18, then release it to them. And that's generally all I had. I just want to quickly summarize what an estate plan should consist of. Number one, it should either have a will or a trust. Make one of the decisions. Do I want a will or do I want a trust? And then secondly, you need to have a guardianship declaration like we talked about. The will, trust, and guardianship come into effect after death. You should also have something to account for if you're incapacitated. You're still living, but you're incapacitated. You want your life to go on. You need to have powers of attorney, as Bilal talked about. Durable power of attorney, medical power of attorney, HIPAA authorization form, medical directive. Have all these documents ready so your life can go on. It's easy on your family if you're incapacitated. And just make sure, a lot of people try to do it on their own. Make sure that you do get an attorney. You don't have to, but of course it's highly recommended. You want to make sure you sign it properly. There's very strict formalities of how to sign it, who witnesses. to make it a legal document. You don't want to create something or not add everything to the trust and then realize it's invalid. It's as if he died without a will or trust. Have an attorney do it properly. That way you can have peace of mind that they took care of it. I didn't do it on my own. I didn't miss anything. And that's my advice. But I'm going to leave this time for any questions you may have, unless you want to add anything to conclude. No?
I think folks may have some questions around the perhaps the Islamic portions of it and things like that. But I think besides that, I would definitely welcome any questions at this time as well. Thank you, everybody. Dr. Siddiqui. Oh. Okay.
I guess that's my.
That's definitely your question.
So the cost varies from law firm to law firm, and it does kind of vary greatly. Um, I can tell you this, reach out to me. I have a set flat fee, and it's reasonable flat fee, and it doesn't change. And if it does change, like a slight increase, it stays like that generally for at least a year or more. So it's not, negotiated or anything. Everyone's going to get the same price. Just reach out to me. Generally, it has the same flat fee. It's a reasonable one, like I said. But sometimes people have 10 properties, so each property is going to be a little extra or whatnot. What'll happen is, I know Bilal offers complimentary consultations. I do as well. Let me know your situation, your kids, your assets, and I'll put it out plainly. This is the flat fee. This is what it'll cover. And just know that, make sure whether you go with me or any other attorney, make sure they don't charge you for follow-ups. A lot of times with trust, after they create it, I say, do another meeting with me and see if everything's in the trust properly, if you have any questions. That way you get to a good point. And just to touch on the trust, once you add everything to the trust, you don't have to do that again. If you buy another property, you just simply buy it in the name of the trust. No amendment is necessary. If you open a business, you make the trust the manager or member and do a company agreement. If you sell a property, you just simply sign off as trustees. Nothing needs to be amended in that situation. So it's just a one-time thing of adding the properties to the trust. But make sure you have an attorney that you can follow up with to make sure everything's initially in there properly. There is no cost to maintain the trust. It's generally you and your wife are managers and everything's in there. The only time I charge an additional fee is, sometimes years later, you want big life events happen or you want to make amendments. I don't want this trustee in there at all. We just do a simple amendment, one-page document, paragraph B is deleted and substituted as follows. Simple amendment like that, but generally we try to create it in a way where you don't have to amend it in the future. But of course, every 3 to 5 years, look at it, make sure you're happy with it. That's a good rule of thumb. Yes, brother. That's a good question. Brother asked, how do you handle assets that are overseas? Bilal can attest to this. Anything we do here is subject to the U.S. jurisdiction. Overseas, they don't care what we say. They don't care if there's a court order or whatnot. You might know more about that, but generally we don't have jurisdiction of overseas properties.
And I think that is a little nuanced as well. Is it just a residential type of asset, or if it's like a business, anything tied to a business? I think that might be an important part of it too. But I agree with what Brother Fawaz just said.
You would generally get an attorney over there, or just make sure you understand the system, how it works in that country.
I can speak.
Whoever. I'm not sure. So Oh, the way I understand it is a guardian or anyone does not have to be a U.S. citizen. It does not have to be. For some reason, if you say, I want my brother to be the guardian and he's overseas, the judge might look at it and say he doesn't qualify. This is not the best interest of the child. The child's already here, so he'll just go to your second option. It's up to the judge, but you put who you want on there first. And it's up to the judge if they pick them or not. They don't have to. The judge always has a final decision on that as far as the guardian. Like the executor or trustee. Oh, I see. I, yeah, yeah. So if you have if you have a will, or I guess that goes through court. If you have a trust, it doesn't. A lot of things can be done remotely, but if you need to go somewhere physically based on the type of asset, they can maybe have someone go on their behalf or something. I recommend, they don't have to be here. They don't have to be U.S. citizens or anything. I do recommend someone local, but to to handle all that, a lot of things are, they can get an attorney on their behalf. They can do things remotely. They don't have to be here, but I recommend someone local. But above that, have someone you trust to grab the money and give it to the beneficiaries according to the trust, more than someone you don't trust. So put who you trust first. Yeah, my pleasure. Yes, brother. Alaikum salam. Tell me you made a estate plan already. Yeah, brother asked about the guardianship declaration and if it applies to the minors. The guardianship declaration is a separate document. It's not part of the trust. It's not part of the will. This is more for both parents are not around and the kids are minors, only if they're minors. Even if you have this and they're over 18, it's just automatically void for them. So it's a separate document to choose a guardian. Yes. Yes, yeah. And just remember the trust is separate than the power of attorney. The trust is a trust itself when you pass away, so you name the trustees on there. The trust should have provisions if you're incapacitated, this next trustee comes in. So you don't really need a durable power of attorney if you have a trust, unless you have items outside of the trust. Medical power of attorney is a completely separate document. Yeah, my pleasure. Yes, brother. Okay, brother asked about the bank specifically, if you have a trust, how to include the trust in there. Um, the options I mentioned are, the main thing is making a meeting with the bank, letting them know you have a trust and you want to incorporate it. They know, they deal with this every day, multiple times a day. They'll say, okay, this person's going to talk to you and give you the options. The two general options they give you, and each bank's a little different, is number one, convert the accounts to trust accounts. The option that I had personally, they changed my bank accounts to trust accounts. The accounting number, the routing number, nothing changed, but now it's a trust account, quote unquote, meaning it's subject to the trust. If me and my wife pass away, my brother's next in line, he has authority. So that's how you convert it. Or the second option is nothing changes, only at the time of death, they name the trust as a beneficiary. As far as which is easier, they're both the same. It's all through one meeting with the bank after you sign the trust. They'll take care of it, and you move on. My pleasure.
Questions. The questions we're going to continue, inshallah. But sisters upstairs and sisters here, they're please welcome to get the food so we can get the process started. Sisters, please, you can come down and get the food so we can get the process started, and brothers can keep asking questions.
I think it's a very good question, brother. If you don't mind, you say it on the microphone.
Are the documents that we are going to get through will and guardianship, are they specific to the state jurisdiction, or they're going to work throughout the nation?
That's a good question. The documents we prepare are state specific. I'm licensed in Texas, so they're state specific. So if you move to another state, have an attorney just make sure they fit the requirements of that state. It's state specific, but if they go to another state, it's good for the attorney just to make sure it hits the requirements of that state, because they're going to be adding properties from that state. They're state specific, yeah. But you can properties from anywhere. Yeah, it's good.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam.
I do have a quick question, brother. I
Yes.
went with one of the attorneys. They actually prepared my will and trust. I do have it in place, but they gave me a bunch of paper documents. So is it officially getting recorded somewhere, or I need to keep those paper documents in case of any, you know?
Like where to keep them?
He got the will and trust, the trust, but all the paper documents that he got them notarized, do he keep them somewhere safe,
Yeah.
or are they officially recorded somewhere?
So that's a good question. Generally, whenever you finish your estate planning documents, you want to keep them somewhere safe. You don't have to record them anywhere, but you want to make sure you don't put them in a safety deposit box. Any trustee or executor named needs to know where they are, and they have to have access without it being an issue. That's the main thing. Now, if you have a deed for a property transfer or something like that, those have recording requirements, but the trust or will itself, they do not need to be recorded.
And I would just practically say again, from recent experience, is that keep it there, let your executor, and everybody that needs to know how to access it. And you may have gotten done a while ago, but for me, they gave an electronic copy of it. I kept that, and I'll have that on file. But really what's important is to keep those originals and keep them in a safe place where they're easily accessible. And then also, if you don't have this already, I'd be happy to, or Brother Fawaz share with you, perhaps a small checklist too. So just a document on top of everything that actually spells out the practical side. So that's why I really like that question, because you're already thinking, in your situation, you already have this planned out, but you're thinking about, again, we're preparing for a time where we're not going to have the ability to think about these things. So I think a checklist would be very helpful, a one-page document explaining some of these things and spelling out, maybe some details about, for me personally, like some of my other valuables, like, just small things to have on there so that they know exactly where my particular favorite watch that I just got last week needs to go. I have some personal thoughts on that, but a checklist. In your practice, do you provide some sort of checklist?
That's a great point. I do provide a checklist, but I also say like, hey, these are the legal documents we made and notarized. These are the legal documents that are going to allow access. You should have a separate list for whoever's going to get it. The first thing they need to know is, what do you own? Here's my bank account, here's my password, here's my properties. That's the number one thing they spend so much time looking for, and a lot of things will fall through the cracks because they don't know you have it. So let them know what you have, and let them know now you have authority over them. So make an ongoing list just for them.
So just to clarify, you said that even if you have an electronic copy, you should keep a hard copy as well?
That's correct. The hard copy, the original, the one you physically signed, is important. And one step further, if you only do a will and you go through court to probate it, they'll only accept the original signed copy. They will not accept the electronic copy. So the original is what's important.
Assalamu alaikum, brother. I have a couple of questions. The first one is, how many times can we change the will and trust or update in a year? The second one is, if the attorney or the service law firm whom we are going with, if they go out of business or they are no more and something bad happens, who's going to update the court and how it's going to proceed?
That's a good question. Brother asked if you want to update a will, or if the law firm that did their will is no longer around and they need to update it, or how many times do they need to update it. The simple answer is you can update a will or you can update a trust as many times as you want during your life. A revocable living trust. Make sure it's not irrevocable. Irrevocable means you cannot revoke it, you don't have power over it, different rules apply. And if the law firm that created it does not need to be the one that amends it. Any law firm can amend a trust. They just simply read the trust, they say, oh, you want to remove this provision, this is what it's going to say now. So anyone can do it, and you have, anytime you want to update it, you're able to.
I got one more question. Could you help me find the right one to choose between the will and the guardianship in the case of children custody? Like if something happens to the family or parents here, what would happen to the kids? And if the wishes of the parents is to have the kids raised in overseas, which one is the best choice, and then how does that work?
So just to touch on the guardianship declaration, so if, God forbid, if I understand correctly, if something happens to the parents, who takes care of the kids? And if your wishes are they go overseas or whatnot? So the guardianship declaration that we provide, you name who you want the guardian to be. Who's their parent now? Who's their caretaker? And you give a few different options in order of priority. The judge is the one that decides at the end of the day. So you say, my brother overseas is who I want the guardian to be. I want him to be solely responsible. The judge sees your wish, and he can grant it, or he can say, this is not in the best interest of the kids, and go to the next choice. So that's really the best you can do, is putting your wishes on the guardianship declaration itself. Did that answer your question? Yeah. My pleasure.
So following up on that same question, on an earlier slide you had the will route and the trust route. So using this logic here, wills are always potentially can go through probate court, like that's going to happen. Trusts won't. What about you said guardianship twice in front of judge, so is a guardianship document always going to be reviewed and approved by a judge?
Okay, brother asked about the guardianship document and kind of how the wills and trusts
Same
play
thing
out.
with power of attorney, everything,
Yeah.
what's enforceable by a court, what's not? Like,
Okay.
probably the better question.
So the will generally is intended to go through the court process. The will is meant to go through the probate process. The trust, as long as the assets are owned by the trust and it's grafted properly, avoids the court process completely. Guardianship is a separate document, it's a separate matter. This is just dealing with your kids. Who is the parent, not who gets what. Who's caring for the kids because the parents are no longer around. The judge has to appoint someone, whether it's a person, whether it's a state, whether someone has to be in charge of the kids. So sometimes the guardianship declaration is part of the will or part of the trust, correct. It could be part of it. Personally, I like to do it as a separate document because it's a separate matter. But yeah, if your will or trust mentions it, it's the same concept. You're still going to name this person as guardian, and it's a separate court proceeding than your assets. Uh, if it's in the trust document, it's a guardianship proceeding. It's not a probate proceeding. It still goes through the court. Yeah, you cannot avoid that. Yeah. Yes. You're going to court for the guardianship for who your kids are, and they have to look at that trust document. Yeah, that's a good question. Why is anyone involved? The judge has to the judge has to determine if that person qualifies. What if this person has a felony? What if they're in jail? The judge has to make a decision based on the best interest of the child, but they look at your guardianship declaration and take that into account. That's just how it is. The judge is going to make the decision instead of you giving it to someone that might not be good for the kids. That's why. Yes, yeah. Yeah, because you're predetermining who you want, but the judge is going to see, is this the best for the kid or not? And there's different rules that apply for that. So if they're minors, minor is disabled or under 18. But if it's someone that's an adult, 19 years old, and they're fine, they're not disabled, they're adults. No one's going to be a guardian for them. Yeah. The judge is going to throw it out. Yeah, but now you can speak about that.
No, you can try, but it's not going to go. But on that same breath, I will say that if you do have that situation where they have an adult disabled person,
Okay, brother, I have a quick question. So I have created a will and trust a while ago. So now if I am getting a home or property, so what is the procedure to bring that to the trust in Texas?
So there's a few different routes you can do it. One that we discussed earlier around having a deed. It's called the transfer on death deed. So you can have that. So that's one route of doing it. Another route of doing it is simply naming, if perhaps it's a new property or an existing property, but let's just use the easier example. It's a new property that you're buying, and instead of having that directly deeded to you, your name and you as husband and wife, you have it deeded over to your trust, and you name your actual existing trust in the deed document. So if it's not a new property and it's an existing one, you'll have to do some paperwork there to transfer that from you personally to your trust.
So what is that paperwork, brother? Is it something we can do all by ourselves, or we need to go to the attorney?
I mean, there's a lot of sometimes I'd say 95% of stuff you could do by yourself.
Okay.
I would say that I'd caution that to make sure that it's worded correctly, that you're using the right type of deed document, and that it is notarized. But I don't think there's actual legal requirement
what is the
that an
process
attorney
called?
has to do it.
What is the process called?
So the first one that I mentioned is a revocable transfer on death deed, revocable transfer on death deed, and the other option is you're doing a deed from your personal to your trust.
Okay, thank you, brother.
Can you just specify revocable, what that word entails here? It'd be very
Revocable,
helpful.
revocable just means technically you can revoke it. You can say this trust is now terminated, and that's really what it means. Where irrevocable is kind of set in stone, you don't have control over it. But revocable living trust, you and your wife are creators, you and your wife are trustees, control over it, and you and your wife are beneficiaries during life. So everything you have control of now, you have control of during the trust term.
So irrevocable means I don't even have control over it?
Irrevocable, yeah. There's specific rules where you cannot be the trustee. Someone else has to be. You cannot be the beneficiary. I forget what they are, but you don't have control and you cannot be the trustee of it. Someone else has to manage it. That's why you get certain tax breaks or certain benefits with it. But a lot of attorneys I know that do general estate planning don't even do those, including myself, because general estate planning, a substitute for a will, revocable living trust seems to be the best option.
Assalamu alaikum.
Alaikum salam.
My question is about building generational wealth. And we all came to this country as an immigrant, and we worked hard for our money, and it seems like our money won't last one generation after us. So, and I'll give an example, for example, organization like Rockefeller was created by someone, Rockefeller, and it's still till now surviving, probably the most known organization. So how we can use this vehicle like trust or will to build that generational wealth and make it last maybe forever?
So when I focus on, so I'm going to focus on one thing first. The Islamic distribution, whenever someone passes away, these people are supposed to get their share, right? So that's what the revocable living trust does. Whenever you do generational, so for example, some people want to keep it going, keep the trust going. You can't have your share yet. You can have a portion of it. I don't know if I'm not a scholar. I don't know if that's withholding their wealth or whatnot. To your point, there's different ways to do that, but maybe Bilal can speak a little bit more about that. If you maybe create a company or serious LLCs, or have it through the company agreement, say, put all the assets in there and have it flow a certain way. But generally speaking, if it's an estate plan and it's Islamic based, that would be hard to do because you're withholding people's right to it. But there's different ways to do it, whether it's through the company route or through the estate planning route. There are trusts that do that, where they continue on, and when someone reaches 40, then it's fully distributed or whatnot. So, and I'm sorry, I hope I answer your question.
No. Yeah. But it's still, my money is not lasting forever, probably. You say after 40 and it's distributed, right?
Right, that's how I've seen them. At some point you have to distribute it, but if you want to hold it and just give distributions.
You speak Arabic?
بحكي عربي.
And I'm talking more about like waqf.
Okay.
Which waqf can last maybe
trust, but then
Can we get back to you on that one?
Okay.
No.
Assalamu alaikum, brother. I have a question. One brother already asked because the cost. So one brother already asked what is the cost will be that, but if someone has any legal plan from the employer, is that will cover under that? They can cover by the employer as well if someone want to make?
So brother asked about the employer provides like MedLife or certain benefits for legal services. There are a network of attorneys on there that can handle estate planning. I don't personally. I'm not in that network. I don't do that with them. But they'll give you a list of attorneys that can handle it.
Yeah, but they still cover under that if someone has legal plan from the employer.
It should cover estate planning. Yeah. Oh, yeah, that's a good point. A lot of them, and I've had people come to me, they're like, well, I can't find one that does Islamic inheritance. And I'm like, they can talk to me, but I tried that. They still are not comfortable doing it that way. You can try. I still don't know anyone. Like reimbursement. So talk to them and see if they reimburse out of network. I'll provide itemized or whatever I need to, but I'm just not in their network.
So I understand neither one of y'all are tax professionals, at least I understand you're not. Is there any benefit, pro and con, to lowering inheritance taxes via will versus trust, like putting your property and selling it eventually, stuff like that? Just trying to get an idea.
So yeah, we don't give tax advice, and I always recommend talking to CPAs or tax attorneys. In general, tax and the trust are going to fall under the same category. But there's you have a lifetime gift amount. It's over 10 million. I forget what it is now. And inheritance falls on that. So if you give gifts during your life and you give everything else to your kids after your death, there's no capital gains up to a certain amount. If they sell it to a third party, of course, there's gains on that profit of that. But from you to them, it falls under that provision.
I have one question, brother.
Assalamu alaikum.
So, how do you ensure the Islamic aspect is brought into this trust setup? Like compared to the other law firms who are doing the trust, which is according to the state law.
Yeah.
How do you actually bring in there?
Okay, brother.
I'm glad nobody asked until this far. Nobody asked that question.
Okay. Like, how do you know it's Islamic distribution? So I'm not a scholar. I worked with, there's an attorney that worked for the ISNA. There's someone at TCU, a professor that specialized in this, and we created a schedule. And there's different ways to do it, but generally speaking, it's straightforward, especially if you have at least one son. If not, there's a few different scenarios if you only have daughters. We put that in the beneficiary, who gets what. Everything else is Texas compliant, and the beneficiary portion is not going to mention anything Islamic. We say, if this person's living, this is who gets what in these portions, and so forth. 100%, yeah. I usually focus on that, the Islamic distribution model, and of course, making it all Texas compliant. Exactly. Yeah, because the trustee is the one that has authority over the bank account, and they have to distribute it out. So at that point, it's their responsibility to do that, whether they're here or overseas. Exactly.
So if the Islamic law is different than the state law, how are we going to proceed with those? How would that be legal as per the state of Texas?
That's a good question. So if you have a will or a trust, you can give your wealth to anyone you want. You just have to do it in the proper format, will or trust. You can say, I give it all to my kids. You can say, I can give it all to my pet if you want. There's no rule on that. So whenever you mimic the Islamic distribution, you can do that. It's just percentages for certain people. There's nothing that contradicts it.
Islamic inheritance law, it's different, a little different than the state law, state inheritance law. So how does that apply?
The state inheritance law only comes in if you do not have a trust or do not have a will. It applies by default. If you have a trust or will, it's 100% according to your wishes, whatever you want. Only if you don't have a will or trust. Yeah. Or with a will, you can say my wishes is to give my mom 1/6, my wife 1/8. According to Islamic law, that's what it is. But if you don't have a will, then Texas law comes in automatically.
Jazakallah khair, both of you.
Of
That
course,
was
of
excellent.
course. Thank you so much.
Everybody would have more questions?
So is that 18 age, is that supposed to be 18 for the distribution, or can I have a age somewhere like 21, 22? Like brother asked, right, what if my kid is, doesn't want to get money for 18? Not for the guardian, anything like distributing the asset or... Yes, distributing. The distributing.
They have to be...
Right. But can we increase it to 21 or 24?
Yeah.
Okay.
As far as, what do you mean, like...
They don't get anything until they're out of college.
Yeah. Once like
the beneficiary.
Yeah, the beneficiaries.
You can do any of my beneficiaries.
Young. It's young, I know.
I know, yeah. 18 is like, you give the money like...
Yeah, it's gone. I agree.
And that's bring us to my question. How to control that money that it will not...
I knew what he was asking. My kids are little and I'm already thinking about that.
Okay, enjoy your food.
No, thank you. I feel like we're at a wedding and we... Thank you.
Thank you all.
Thank you, brother.